Intellectual property creation and management for emerging growth technology companies. Building a patent portfolio. This presentation is brought to you by the IP attorneys and professionals at HULSEY Intellectual Property Lawyers through the HULSEY Intellectual Property Technology and Invention Monitor website. HULSEY Intellectual Property Lawyers, IP professionals for entrepreneurship's new golden age. This presentation is part of the Technology and Invention Monitor website's Legal and Business Issues and Instructions resource. Intellectual property creation and management for emerging growth technology companies. Building a patent portfolio. Let's begin the presentation.
When an inventor comes to the preparation of an invention disclosure form or the disclosure document, the processes of building the system will include a number of reviews. One aspect of looking at this process is to make part of the process that determines what steps are going to be made, whether it's oversight, whether it's generating new patents, whether it's portfolio maintenance and competitive assessment, can be of value in receiving the invention disclosure and assessing the value of an invention relative to the subject matter of the disclosure. Those things which go into the patent review meeting include, of course, a survey or some type of input from the business leaders or the strategic business unit managers. Those can go into and need to go into the input for the coordination function in preparing for a review meeting. Evaluation, guidelines, and checklists, and I'll show you some of those and how those might be used. The disclosure, the publishing of the disclosure within, let me back up here. What also goes into the meeting are recommendations by engineering managers, as well as recommendations from the legal department by the IP attorneys. So in preparing for a review meeting, an invention review meeting within a company, these inputs of checklists, of general manager survey forms, of the invention disclosure itself and recommendations, as well as technical and legal input from the IP department, the legal IP department within a company, will generate certain outputs. And these outputs include a published disclosure at times to relevant persons for the purpose of making the invention public. If a decision is made to not pursue patent protection, the reason someone might publish as opposed to seeking patent protection would be to make it public information what the invention is. That public information can be useful, or it can, but it being public will keep others from later inventing the same subject matter, obtaining patent protection for their invention, and then precluding you from doing something that you have the right to do because you were actually the first inventor. So the published disclosure is an action that can be determined at the invention review meeting. One example that you'll see oftentimes is the publication of white papers. The IBM Technical Bulletin has as part of its function the publication of inventions that the company has decided not to pursue patent protection for. Other companies have technical bulletins that constitute public disclosures that dedicate to the public the inventions that the company decides not to pursue and not to protect. It may be appropriate and possible to keep the innovation that's described in the invention disclosure as a trade secret. And if that's true, then that may be a substitute or maybe an interim measure that would help in the decision not to file for patent protection, and we'll talk in some degrees about how that might work. And then there may be the decision within the invention review meeting to file for patent protection. Now, if that happens, of course, there's the need to determine who's going to file it, whether it's going to be prepared by in-house legal staff, the application itself, or whether the outside counsel will be tasked to prepare the patent application and be supervised and managed by the in-house patent counsel, or if there's not in-house patent counsel, to work with the appropriate chief technology officer, or if there is in-house counsel other than patent counsel, to work with that counsel for the purpose of preparing the application. Here's a description of some of the information some of the interfaces and knowledge databases that support the IP enforcement and competitive analysis process. So taking a look back here, we're looking at the oversight and innovation process and the generating of new patents. That's what this diagram details in some measure of process. And then further, the portfolio maintenance, competitive assessment, as well as some of the management details relating to your patent portfolio database management and your competitive assessment database. Moving down, there's certain inputs that can come into the process and can provide you with certain outputs that are useful. For example, there can be input from strategic planning, technical and business, and senior management that can lead to product selection decisions, and product family databases can also lead into this process. Enforcement information can go to the legal department and be filed in terms of databases for competitive assessment, and also technical assessment of products is something that goes on, and this information, the infringement databases, can also and need also be maintained. The technical assessment of products communicates with, or at least relies upon, the existing know-how within the company. So too is the case that the enforcement decision information that goes to the legal department will rely on the know-how that exists within the company. These databases and the analyses that come from these databases and information also feed into the activities that occur in the legal department, as well as the competitive and technical assessment of products. Also, licensed databases are resources that take place or that exist within companies and can be useful in making decisions about what to do with these intangible assets. An output from a legal department analysis will be negotiation with potential or alleged infringers, the licensing of the intellectual property rights. In fact, licensing in and licensing out can be part of the understanding that comes from the utilization of these inputs from the existing in-house product family databases, as well as the strategic planning, technical business, and senior management input. Out of the license database functions, the interfaces include links to the larger IP generation community within the company, as well as using the existing know-how. So there's a lot of information, a lot of resources that can be applied in this competitive assessment and in the further decisions that take place within the company. So moving on within the system, there are further things that occur. We've talked about some of the valuation processes that occur, but there, as well as the activities of valuation, there's the business and market strategy review and analysis, some of that being described in this dynamic diagram, as well as decisions as to where you're going to get technology, whether it's external sourcing or internal sourcing. This information can be useful for the purpose of determining just how a company will respond and some of the decisions that need to be made on a recurring and ongoing basis. What are you going to patent? What are you going to maintain? Where are you going to get your innovation? And how are you going to categorize and perform initial valuations of the IP that exists within the system, within the company. And these circles indicate the actual decisions, the dynamic decisions that take place. One of the things that needs to be done in deciding the patenting decision also relates to the valuation decision and the innovation decision, the sources of innovation, and may in some ways connect with the budget and maintenance fee decision analysis. And what I'll provide to you in the following are some of the guidelines that companies can use for the purpose of determining the scope of patent protection that's available, the predicted value of the patent rights that might be obtained, the degree of ingenuity in the item can be assessed, part of the ongoing process, and the extent of possible adverse impact on the company if details of a new innovation or item were to be disclosed to the public, or if rights to a particular innovation or item were to be acquired by others. Some of the factors that go into these analyses include the realization of the understanding of rapid technological obsolescence, what alternative technologies are, the patent validity risk that may exist if you do get a patent. In other words, have there been disclosures? Do you need to be concerned about that? Changing consumer reactions. These are some factors that can determine the length of the benefit, the economic benefit that the company receives. There's certain risks that you need to take into consideration also when you put substantial corporate resources into the intellectual property development process. And that includes looking at what the economy is doing these days in the technology economy There are tremendous transitions that have occurred and that probably will continue for some time. Those external risks need to be factored into what you're going to spend company resources on for the purpose of obtaining intellectual property rights. Are there regulatory risks in terms of encryption of data or toxic chemicals or exportation of technology? Are there political risks? Those can be addressed and should be to some degree, and they really kind of come into these decisions whether people desire to talk about them or not. They really do exist. Inflationary risk, unanticipated events, these are risks that need to be considered concerning the economic benefit of a given technology. So when you review an innovation, what follows are some questions that can be helpful in determining what to do with the innovation. A factor with some of the following considerations is that no single factor is more important than others. A first question to think about with regard to an innovation is what is the relationship of the invention to the company's intellectual property plan. You remember we talked about in an earlier module the Hewlett-Packard, the Xerox, the Merck strategies that they were pursuing with regard to their portfolios. With regard to a new innovation, asking that question can be seminal in determining what to do with the innovation. Does the company invention rate relate directly to work being done under any company-funded program? Sometimes companies deal with different types of funding for programs. Those might be externally funded by strategic partners. They might be just internally generated. Sometimes companies deal with government contracts. Sometimes they deal with university contracts. Sometimes they deal with others. And understanding the source of funding for a particular developmental effort can be key in determining what to do with it. Was the invention conceived or reduced to practice under a government contract? All companies of any size have some measure of involvement with the government, whether they're software development companies or whether they're semiconductor equipment development companies or whether they're device fabrication companies. There's some involvement oftentimes with the federal government pursuant to a government contract for a specific innovation, and some of the cutting edge and leading technologies can and will be funded by government contracts. If that's the case, then understanding what the ramifications are of that government money with regard to the intellectual property rights can be key. A further question: does the invention function as anticipated, and is the technology feasible? Does it make sense? I've seen many patents that have been filed on technologies that for which the invention was not actually reduced to practice, but for which the application was filed, relying on the description, relying on the expertise of the inventor. It's not always the case that the invention will function as anticipated and that the technology may not be practically feasible, and if that's the case, it may not make sense to file for patent protection. Has the invention been or is the invention to be incorporated into a company, product, or service? We'll talk about what to do with a given technology, but if that's the case, that may give you a stronger incentive to obtain patent protection. Will a product or service that incorporates the invention improve the company's competitive advantage? A tick mark there may be real strong with regard to patent protection. And then what is the relationship of the invention to the company's present and future product lines? It may be that invention that has marginal use today in an existing product line or in a short-term product line may be substantially more important in later product lines, and that can give it increased importance as to whether or not the patent should be filed. Does the invention have impact on present and future processes within the company? Take a look there. Is there a plan to incorporate the invention into a company process? Will a productivity improvement result? Sometimes the inventions that make a company competitive have to do with its operations, and the ability to be the only company in a competitive field that can practice that invention, if it's discernible that that invention has in fact been practiced, for the own purpose of keeping others from practicing the invention, can give you the motivation to go ahead and file the patent application. Will a product incorporating the invention favorably or adversely affect the cost of manufacturing? Well, if that's the case, then, or determining whether that is the case and in which way, can be determinative as to whether patent protection should be sought. Another question that might be interesting to review is what, if any, investment will be required to manufacture a product incorporating the invention or utilizing a process making use of the invention? If substantial complementary assets are necessary to either be purchased, leased, or otherwise brought into the company for the purposes of practicing the invention, it may not make sense to pursue it. It may be outside the core competency of a company so much that for that invention to see the light of day, the expense would be impractical.